Mr Costello.
Commissioner, the next witness is from the Commonwealth Bank of Australia, Linda Marie Elkins.
Is Elkins here? Is Elkins, do you wish to take an oath or would you prefer to make an affirmation? Yes.
I swear by Almighty God.
I swear by Almighty God
That the evidence I shall give.
that the evidence I shall give
Will be the truth.
will be the truth,
The whole truth.
the whole truth,
And nothing but the
and
truth.
nothing but the truth.
Thank you very much. Do sit down. Yes.
Ms Elkins, can you give the Commissioner your full name, please?
Linda Marie Elkins,
And your business address?
201 Sussex Street, Sydney.
And have you received a summons to appear today before the Commission?
I have.
Do you have a copy of the summons
I do.
with you? I tender the summons, Commissioner.
Exhibit 2.70, summons to Ms Elkins.
Ms Elkins, have you given a witness statement that is dated 5 April 2018 to the Commission?
I have.
I understand that you wish to make a correction to subparagraph 3D of your statement.
Yes.
What is that correction?
I realised I have resigned my directorship from my membership of the Financial Services Council Superannuation Board Committee.
And when did you resign?
I think it was effective the 4th of April.
Can I ask you to just amend paragraph 3D of your statement to reflect that change? And will you initial that change that you've
Yes.
made to the statement? With that change, is your statement true and correct?
Yes.
Commissioner, I tender the statement and the exhibits to it.
The witness statement of Ms Elkins and exhibits
Yes, there.
will be exhibit 2.71.
Thank you, Commissioner.
Yes, Mr Costello.
Thank you, Commissioner. Ms Elkins, you're the General Manager of Colonial First State,
I'm the Executive General Manager of Colonial First State.
and you've been in that position since.
2012.
And in your witness statement, you mentioned two legal entities, Colonial First State Investments Limited and Avantios, is that the correct
That's right.
pronunciation? Investments Limited.
Yes.
Are you responsible for both of those entities?
Yes, I am.
And in the scheme of the Commonwealth Bank, where do those entities sit? To who do you report?
I report into the Chief Operating Officer of the Wealth Management Division,
And who's that?
Michael Venter.
Right. Now, there are other legal entities with the name Colonial First State within the Commonwealth Bank group.
Yes.
Is the entity for which you're responsible related in any way to Colonial First State Global Asset Management?
Colonial First State Global Asset Management is also a subsidiary of the Commonwealth Bank. The businesses at one time in the past, the dates I wouldn't remember, were joined together. This was one business that has been split over time.
Right. So you're not responsible for Colonial First State Global Asset
No,
Management?
not at all.
All right. And what is the business of Colonial First State that you're responsible for?
I'm responsible for the platform business, to oversimplify it, I guess, for the platforms within Colonial First State,
Right.
both the Master Trust and the WRAP platform.
Is platform a convenient expression to describe both master trusts and wraps?
That's correct.
All right. And in your witness statement at paragraph 13B, you also mention private label wrap products.
Yes.
What are private label wrap products?
Private labels is where another entity would be using our administration services, but we're not the trustee or the product issuer.
I see. Now, you've been put forward by the Commonwealth Bank to answer some questions that the Commission has put to the bank about platform fees.
Yes.
Other of those questions will be answered by Ms Perkovic?
Yes, that's right.
All right. And what was the reason for the division between the two of you?
Because of the separation within the business of where responsibilities lie, one of the ways we think about management of conflicts within a vertically integrated business is to think about how the businesses need to be split and having different leaders responsible for different activities. So the questions you're referring to were in regard to advice business APLs,
Yes.
which is something I have no responsibility or visibility over.
When you say APL, you mean approved
Sorry,
product list?
approved product list?
Yes, all right. Now, in paragraph 15 of your witness statement, you set out two tables. You can see
Yes.
it either in your hard copy or on the screen, whichever's more convenient to you. And in those tables, you set out which platforms Colonial First State, I might call CFS,
Okay.
offers, and
Yes.
which platforms AIL, which is Avantios, offers, and whether they are available to affiliated advisors or unaffiliated advisors. Could you explain to me first, in this context, what you mean by an affiliated advisor?
Affiliated with the Commonwealth Bank.
An example of an affiliated advisor would be an advisor working within CFPL.
Yes, Commonwealth Financial Planning Limited,
All right.
Financial Wisdom, or Count, and previously Bank West Financial
Yes.
Advice.
Yes, and an unaffiliated advisor is anybody else.
Correct.
All right. And why is it that some platforms are made available to affiliated advisors, some to unaffiliated advisors, and others to both?
That only happens in the Avantios part of the business,
Yes.
and that would be where there's a white label arrangement in place.
And if there is a white label arrangement in place, does that mean it would be available only to an unaffiliated advisor?
By nature, that white label would be made available to the licensee responsible for it, although it can happen that it is also made available to other advisors, or it can happen that an advisor who is affiliated subsequently goes to another licensee but can continue to write the product. But generally, that's right.
All right. I'm not sure I entirely understand the white labelling process yet. If I'm a consumer and I go to an unaffiliated financial advisor and they give me advice to make an investment through a platform, and it happens that platform is a white label platform manufactured by Avantios.
Yes.
I won't know that it's Avantios, is that right? It'll be labelled something else.
The label would be the relevant white label, but it would be disclosed in the PDS
Yes.
that the administrator or product issuer is Avantios, and that is a subsidiary of the Commonwealth Bank.
Would the white label typically be the brand of the unaffiliated advisor?
Typically, yes.
Right, thank you. I want to ask you a few questions about...
Sorry, I mean, you can see that I don't think the name is the same. Like, it's not, for example, in Count, it's not called the Count white label, it's called Star Portfolio. So it would be the brand name that is...
The unaffiliated advisor might have a platform brand name
Yes.
that they distribute, and but your entity would be the manufacturer.
Yes.
Thank you. I want to ask you some questions about platform fees. Generally, what are the type of fees that Colonial, if I can refer to it, Colonial as being both entities, charges for platforms?
So the fees are either administration fees that we charge for running the platform, or we charge fees that we then pass on to service providers such as investment managers or insurers.
All right. Can I take you to an exhibit to your witness statement? It's LME 59, which is CBA 9000.0003.0041. This is a spreadsheet that you have exhibited to your witness statement that
Yes.
sets out some fee types for Colonial First State Investment Limited products. And the first one noted there is an investment fee.
Yes.
Now, what is the investment fee?
The investment fee is, in this case, we're looking at the CIFSL entity. The CIFSL entity is a master trust structure and uses a mandate structure in terms of how it purchases the underlying investments. So in that case, the investment fee relates to the fees that would be paid to that underlying investment manager and administration fees paid to us for carrying out the unit price functions, excuse me, in relation to those investments.
You said it uses a mandate arrangement.
Yes.
Could you explain what a mandate arrangement is?
Yes, so a mandate arrangement is where we buy our own vehicle from the relevant asset manager rather than investing into one of their existing managed investment schemes.
When you say your own vehicle, do you mean you establish a managed investment scheme that is for your particular use?
I'm not sure that it's a managed investment scheme. We refer to it as a mandate. It may be technically, but it's our own vehicle with that investment manager as opposed to pooling into a vehicle with other investors.
The investment fee that's listed in this spreadsheet, that's a fee paid by the investor? So that when we carry out the unit pricing function, the fee that is charged is included in that unit price. So it's charged across the fund as a whole, as opposed to per individual account. Is the investment fee a one-off fee or is that a recurring fee?
That's a recurring fee.
And how often would that ordinarily be charged?
It's charged monthly.
Charged monthly. And what's the basis by which that fee would be calculated?
The funds under management.
All right. And then the administration fee is the next fee in the spreadsheet, and there are
Yes.
2 administration fees noted there. What's the administration fee in a general sense?
The administration fee is the fee for carrying out the client operations, if you like, for managing the administration services in relation to the client's account.
And how often would an administration fee ordinarily be charged?
Monthly as well, part of the unit price.
And the investment fee and the administration fee are in addition to fees that might be charged by the fund manager, is that right?
No, that's included.
They're wrapped together.
Yeah, so the fee that an individual would pay depends on which investment they chose.
I see. And would that be the case for all products, all platform products across the Colonial First State portfolio?
I believe so, yes.
All right. So all consumers that invest through a Colonial First State platform will pay, as a general rule, an investment fee and an administration fee,
Yes,
but they will not pay a fee to the ultimate fund manager. Is that right?
we pay that fee.
You pay that fee. So that fee is incorporated within the investment
into the
fee?
unit price, yeah.
I see. All right. And the fund manager's fee would ordinarily be calculated by reference to funds under management, or
Yes.
sometimes called funds under administration.
Yes,
And your investment fee is also calculated in that way?
yes.
And is the administration fee calculated
Yes,
in
it
that
is.
way? And what's the relation?
Sorry, I'm
Sorry?
sorry, but you can see here on the exhibit, administration fees can be dollar-based
Yes.
as well in some
What's more
cases.
common?
Funds under management.
And what's the relationship between funds under management and the administration expenses that the platform operator might incur?
So the main relationship between those things is I guess the risk we carry in relation to the unit pricing function that we carry out. And there can be a relationship, although it will vary, between the amount of service that would be required on the account. If the account balance is higher, there can be additional servicing needs, but I would say it's predominantly the risk in relation to the higher amount.
All right, so you've mentioned risk and servicing. Can I deal with risk first? What's the risk that you're exposed to?
If we get the unit pricing is incorrect, then we would be responsible for the remediation of that.
Does that happen often?
No, it doesn't. We are obviously there is audit functions that are carried out with our external auditors, and we perform at we believe we're at industry best practice.
Presumably, correct me if I'm wrong, the unit price would be at least in part a function of the total value of the underlying investments.
That's right.
And it would need to be divided by the number of units issued.
Yes.
And explain to me the other vagaries that create the pricing risk
If we made an error, if we got it wrong,
in the division?
or in things like the withdrawal of the administration fee, or in the recouping of expenses, or wherever it might be.
You charge more against the prospect that you might do something wrong.
The question you asked me was, what's the relationship? So no, I wouldn't say that is the relationship, and I would also agree that it is industry practice that these fees are asset-based.
But you would also agree that you're pricing in your risk
Yes.
of miscalculation,
Yes.
which might result in a requirement for remediation.
Yes.
And that affects the price the consumer pays.
Yes.
And that's the risk component. And the other component was the servicing component.
And again, that's not necessarily a direct relationship, but it is a factor that can be. So I would agree that using asset-based fees is the common method that's used in the industry.
What type of services are contemplated by the servicing fee?
So the servicing fee covers the administration of the account, so the application process, any redemption process, call centre activity reporting, and so on.
The application process would not be covered by an initial application fee, is that right?
It's included in the administration fee.
There's no separate application
No,
fee?
there's not.
And is there a separate fee for redemption?
No.
All right. So,
Historically, there has been differences over time, but at the moment, no.
so entry fees and exit fees have now been merged into an administration fee, and the administration fee also includes
functions
call
covered.
centre type activities. Is that your
Yes.
evidence?
Yes.
All right. And the administration fee will generally be charged by reference to funds under management.
Yes.
And is there any relationship between the administrative tasks that Colonial would undertake and the amount of funds under management?
As I said, it would vary. I mean, no, this is the standard method that the industry uses.
This is almost uniform practice within the industry, isn't it?
Almost uniform. There are products that are that are dollar fee based.
Are they newer products as a general
Yes.
rule?
Yes. In our case, I can't speak for the broader industry.
And if I can take another asset class, for example, that a consumer might consider making an investment in, a consumer might have an ability to, say, invest in direct property
Yes.
or invest in a managed fund through one of your platforms. And if the consumer invested in direct property, they might appoint a manager to manage the property, and that manager might charge a fixed fee, might charge a flat fee, or might charge a fee based on rent received, that is the income. But that type of arrangement would almost never involve a fee based on the capital value of the property acquired. Is that how you would understand a direct property investment to work?
I think that's fair, yes.
So that's quite a differential method of calculation of fees between that particular type of investment, the type of investment you offer.
Yes, that's fair.
And the principal reason why fees are recouped on the basis that they are is historical practice. Do you agree with that?
I think that, yes.
All right. And has there been any consideration given to whether or not it remains appropriate to charge fees by reference to funds under management when the costs incurred by the fund manager are not referable to the amount of funds under management?
I haven't been involved in those discussions.
If there had been discussions within Colonial, would you have been involved?
I should say, obviously we have launched products that are dollar fee based. So our thinking around that was that's a new product that we've brought to market to see what the appetite for that was.
What's that product called?
That's the ComSec portfolio service.
When did you launch that product?
I'm sorry, I can't remember the launch date. It was relatively recently.
Would it have been this year?
No,
Last year. All right. And that's the only product you have?
Other products in the white labels, for example, the arrangement could be a combination of asset-based and dollar-based fees.
Have you got any products where the investment fee is anything other than a percentage of funds under management?
There's term deposits are available on these platforms, so that's a different. They're obviously subject to the interest rate.
So I want to make sure I understand that. Are you saying if somebody invests in a term deposit through a Colonial platform, they're not charged an investment fee based on funds under management?
Not the investment fee, they would be charged, they can be charged an administration fee, but they would receive the interest rate that's relevant to that term deposit.
That's what they would receive?
Yes.
My question is, what would they pay?
They would pay just an administration fee.
All right. Can I deal quickly with the expenses that Colonial might incur in administering or operating master trusts and platforms? And can I take you to Exhibit 56 of your witness statement, which is CBA.9000.0003.0037? Are you familiar with this spreadsheet?
Yes.
Upon seeing it. This is a spreadsheet where you have had your staff at Colonial set out by totaled categories the expenses incurred in relation to operating your portfolio of platforms. Is that right?
This spreadsheet's in relation to SIFSL?
Only.
Yes.
That's Colonial First State only,
Yes.
not Avantios. Thank you. And you can see at the top, in the grey column, it says expenses, and then it's got a dollar sign and 3 zeros. So these figures take, for example, the first figure for financial year 11 in column 6, which says 162,534. That's actually 162,534,000, is it?
Yes.
All right. And then if you go down to row 12, perhaps if rows 12 to 15 could be made a little larger. Thank you. There are commission expenses,
Yes.
and that starts in financial year 11 and runs through to financial year 17.
Yes.
And it's broken into two categories: related parties and third parties.
Yes.
Related parties are other Commonwealth Bank entities. Is that what that means?
That's the advice entities that we described before.
CFPL, Count,
Financial Wisdom.
and formerly BWFA,
Bankwest,
which was
yeah.
Bankwest. All right. So your business, to take financial year 11 to begin with, paid, what's that, $53 million in commissions to other Commonwealth Bank entities?
That's right.
Is that right?
Yes.
And in that same year it paid $127.5 million nearly in commissions to third parties. That means unaffiliated advisors,
right.
does it? All right. And you can see that the figures continue through to financial year 17. Now, beyond financial year 13, once FOFA commenced,
Yes.
are these grandfathered commissions?
They are.
And do they include volume-based shelf space fees?
No, they are just the commissions.
Do you pay volume-based shelf space fees?
We're grandfathered volume-based fees, we do.
You don't pay volume-based shelf space fees otherwise?
No,
And why is that?
because FOFA.
But you're aware, aren't you, that there are two exceptions to the general prohibition on volume-based shelf space fees? Are you aware of that?
Sorry, where they're covered.
Where,
under the
where you
grandfathering
are,
provisions.
where it is still permissible for
Oh, yes, I'm sorry.
for them
Yes,
to be
we
paid.
pay those, yes.
you still do pay them.
We do, if they're
Right.
permitted under FOFA.
So beyond 1st of July 2013, these figures would be both grandfathered commissions and permissible volume-based shelf space fees.
No, the volume-based rebates, I don't believe, are in those numbers. We can confirm that, but I don't believe so. I believe that's just the commissions.
Do you receive volume-based shelf space fees?
From fund managers,
Yes.
you mean? Yes, we do, prior to them ceasing as well under FOFA.
Yes, and to the extent they're still permissible, do you still receive?
We do, and there's, in my witness statement, they are described.
Yes, thank you. Do you have an understanding of the exceptions to the ban on volume-based shelf space fees?
Yes.
Could you perhaps explain to the Commissioner, so far as you're able, what a volume-based shelf space fee is? I'm not asking what a permissible one is, I'm just asking as a general concept, what is the concept?
The concept was that fund managers were paid us for access onto the platform and for the carrying out of administration tasks in relation to that.
All right. And who do you pay volume-based shelf space fees to now?
To licensees where that is permitted under the grandfathering provisions.
And who do you pay commissions to?
The same to the licensees where that's permitted under FOFA.
All right. I want to ask you a few questions about charging of fees. That spreadsheet can come down now, thank you. Can I take you to paragraph 30 of your witness statement, which is at CBA 9000 0008 0001 at 0011? Actually, if we could go back one page first, I'll just show you the question that you're responding to here. Can you see question 5 there? Just make it a little larger, thank you. You were asked this question, in respect of each identified RAP platform or master trust during the period of 2011 to date, what are the systems or procedures that govern whether a fee identified in answer to 3A above, that 3A above is where you set out the general fees that you charge for your platforms, is automatically charged to a client, and how it is or was, or how is or any or was any fee calculated? And then we asked you to expand on your initial answer in A1 there by saying how members authorise Colonial or Avantios to deduct an advisor service fee or an ongoing advisor fee. That was the question, and if I can take you to paragraph 30 of your statement now. You said there, you can see members are required to authorise the payment by Colonial or Avantios, as the case may be, of any advisor service fee, including any ongoing advisor service fees to any dealer group or financial advisor. Just pausing there, when you say members are required, who are members?
Customers, investors.
Right, I see. Members of the fund.
Yes.
This authority can only be given by a member via appropriately executed request. This authority is typically included as part of the application form for an interest in the relevant offering, but may be provided in a standalone document. So, in addition to any fees that you charge as platform operator, an advisor service fee might also be deducted from the value of the client's investment. Is that
but
right?
there's been an agreement between the customer and their advisor, then they can authorise us to deduct that fee.
I see. And where's it deducted from?
In the case of CIFSL, by redeeming units from their account. In the case of Avantios, the wrap business, from the cash account that it operates through.
I see. Colonial's ability to deduct fees from clients' investments is in effect what allows ongoing service fee relationships to work in a practical sense, isn't it?
That's right.
You're the conduit between the client's money and the payment of the ongoing service fee.
Yes.
All right. And you would appreciate that ongoing service fees are a very significant income stream for advisors.
Yes.
And a very significant income stream for other Commonwealth bank entities such as CFPL.
Yes.
All right, can I take you to paragraph 31 of your statement now, please? Sorry, 31. This is now in respect of fee disclosure statements or renewals. You
Yes.
say there the fee recipient, that is the financial advisor or dealer group, has the obligation to send fee renewal notices and seek confirmation that their client wishes to renew the ongoing fee arrangement. Does Colonial take any steps to ascertain if fee disclosure statements have been sent by the financial advisor?
So what we do is require licensees, dealers, to enter into a dealer terms of trade with us.
Yes.
That where they're providing us a warranty that they will comply with their obligations.
Does Colonial take any steps to ascertain if a fee disclosure statement has been provided before deducting the fee?
We're not involved in the process of sending the fee disclosure statement. This is something we have given consideration to, what our role could or should be in relation to this. We first considered this when we were introducing FOFA and becoming aware that licensees would have this obligation to see whether that was a service that we could or should assist with. What we found, though, was because the fee and the part of the relationship that's visible to us is just in relation to this product, that we didn't have visibility of the whole relationship, and often somebody can hold more than one products. Plus the key interactions that happen under this agreement. For example, one of the most valuable parts of the service often is the face-to-face annual renewal, is not something we're a party to. So the view we take is that we are interested in assuring that the fee is properly incurred in relation to the part of the fee that relates to this product, but we don't have a process by which we're monitoring or supervising the sending of the FDS. We're using the dealer terms of trade to ensure that they are obligated to advise us through the dealer terms of trade if that doesn't occur,
Right,
the licensees.
Well, I'll come back to the dealer terms of trade in a moment. I think there might be two concepts being conflated in your answer. The first is that I asked about is fee disclosure statements.
Yes.
And fee disclosure statements are separate from, but in some sense related to, the delivery of ongoing service. Would you agree with that?
Yes.
All right. So the question that I asked was whether Colonial takes any steps to ascertain if fee disclosure statements have been provided.
We don't. We require the licensee to advise us if the renewal doesn't occur.
And while you've pointed to some difficulties that you might have in ascertaining whether service has been provided under an ongoing service fee arrangement, it's not the same difficulties in ascertaining whether or not a fee disclosure statement has been provided, are there?
There could be. For the relevant licensee would need to look at the fee disclosure statement and then potentially send to each of the product providers assurance. So the fee disclosure statement would relate to all of the products and services that's being received under that statement,
Yes.
of which a single product would be one of the services. So
Single product being one of your platforms?
it could be, yep.
Yes.
Yeah.
And so by seeing a statement of the type that you've just described, you'd be satisfied that there had been disclosure made in respect of your platform?
Sorry, I didn't understand the question.
If you saw a fee disclosure statement that expressly included a reference to one of your products, you would be comfortable that there had been disclosure made,
Yes.
and that would give you a level of comfort in deducting fees.
Yes, and the way we receive that comfort is by requiring licensees to notify us if that doesn't occur, or if the renewal doesn't occur.
Because the obligation lies with them.
The obligation lies with them. The other piece of this that I think is important is the additional disclosure. So if we start with what the client sees, which is the fee disclosure statement, and then of course they've got the 2-year renewal process in regard to what their advisor sends them. In addition to that, their disclosure from us as their product provider will clearly set out the fees that are related to their holding in that product. So we are that disclosure of the fees that relate to the holding in the product or platform that's relevant to me is disclosure that I'm also continually making visible to the customer.
I see.
So in that regard, the customer also has the opportunity to turn the fee off at any time, or to be aware if they haven't received the fee disclosure or the renewal process.
Do you accept that it's a large step to deduct an amount from a client's investment?
Absolutely, yes.
And it could be a particularly large step because of the compounding effect of fees being taken from client investments.
Yes, I do accept that, yes.
And you could require, couldn't you, dealer groups to confirm in respect of each client that they have fulfilled their obligation in respect of fee disclosure statements. That's not beyond possibility.
It's not beyond possibility, but I think we would want to understand what the system capability would be required for that, versus at the moment what we have is the obligation for them to advise us when a failure occurs.
Well, there's any number of methods, aren't there? At one end of the spectrum, for example, you might require positive proof of the fact that a fee disclosure statement's been provided.
Yes.
And perhaps at the less rigorous end, you might conduct randomised auditing of the licensees to see whether or not they have been provided.
Yes, that's right.
But at this point, you don't do either.
We're not doing the auditing, but I think you're right. I think that is steps that we could add to the way we're administering the dealer terms of trade that would improve.
You say steps we could add. Is there any current plan to add?
To be honest, I think through the course of the Commission this week, there has been, it will be something that I will be going back to the office and doing, yes.
All right.
Yep.
You've mentioned the dealer terms of trade. Can I take you to paragraph 31 of your statement, please? And you'll see at the second sentence there, that it's on the screen or you can use your hard copy, that you impose rules and limitations in terms of trade that are binding on each relevant dealer group,
Yes.
which includes an obligation on each dealer group to comply with its obligations under relevant law.
Yes.
And then if we go to paragraph 32, you give some detail of the terms of trade with dealer groups, including a requirement that dealer groups comply with statutory ongoing fee arrangements and requirements. And that paragraph concludes with a reference to subclause 2.1c of the dealer terms of trade that require the dealer group to comply with the Financial Services Law, which includes the relevant Corporations Act obligations. And that's the type of obligation that you were alluding to in your evidence a little earlier. Is that right?
Yes. Yes.
How would Colonial become aware that a dealer group was in breach of a statutory obligation?
We would expect the dealer group to advise us.
Insofar as the dealer group concerned is affiliated, that is, it's a Commonwealth Bank subsidiary, for example, say CFPL, the contractual terms that you've pointed to in paragraph 32 are not enforceable in any practical sense, are they?
Yes, they are, because we could off-board, we could cease to deal with the relevant licensee.
Sorry, what was your answer?
We
You
could
could
stop
off-board
dealing
them.
with them.
Stop dealing
we could
within the
off-board.
group?
or any.
You were asked about company within the group. Are you
we could do
telling me that you could cease to deal within the group?
The power would be there for us to do that.
I understand the power may be there. Are you telling me that's a realistic possibility?
I would think that would be unlikely, but not impossible. And I think it would. The governance structure we have in place across these entities, they are governed by independent boards. So I do think it would be possible, but I would agree that it would be unlikely, and hopefully because we would have knowledge of the steps being taken to remedy any situation.
Well, let me put a few things to you in that connection. It's inconceivable, isn't it, that Colonial would sue another Commonwealth bank entity for breach of that sort of a term?
I honestly don't know the answer to that. The situation hasn't arisen.
It hasn't arisen.
I think that's the point. It hasn't arisen. Yes, go on.
When you say it hasn't arisen, what do you mean?
There hasn't been a case I've been involved in where we've been considering that.
But it certainly has arisen that affiliated entities have breached their obligations under the Corporations Act, hasn't it?
Yes, that has happened.
And when you say it hasn't happened, what you mean is you haven't considered whether to take any action as a consequence of a breach.
No, what I'm saying is we, knowing the action that the entity was taking, satisfied us that we didn't need to consider taking any further action, that rather what we were focused on was ensuring that the relevant entity was appropriately considering remediation and redress where that had occurred or if that was necessary for the clients.
It's inconceivable, isn't it, that you would kick CFPL off a platform?
I would have to agree that that would be unlikely. I don't know that it's inconceivable. It's said with independent board structures it's possible, but I do agree with what you're saying, yes.
Colonial's a wholly owned subsidiary of
Yes,
Commonwealth Bank ultimately?
Yes.
And do you understand whether or not the directors of the company are ultimately allowed to act in the interests of the ultimate holding company?
No, we're there to act in the interests of our investors.
Yet you say it is almost inconceivable that you would remove CFPL from a platform if it was, say, in egregious breach of its Corporations Act obligations.
But no, in that case it would be conceivable because of the, at least because of the independent board structure. I'm saying in the cases that have occurred, we were satisfied with the actions that the licensee was taking in regard to remediating for the customers that we are responsible for.
How many non-Commonwealth Bank entities have you taken action against for Corporations Act breaches?
I couldn't. There have been licensees that have been off-boarded, but I don't know the answer to that. We'd have to let you know.
When did that last happen to your knowledge?
I would have to check. I'm not sure. Yeah.
Are you aware of it occurring since August 2012 when you started in your current role?
It may have. I'm not sure.
And you've mentioned a few times the board and the role of the board. Would a decision to take action as a consequence of a breach of dealer terms of trade be a decision that would ordinarily reside in the board?
No, but if it escalate, well, I would rather if the board became concerned, it could go either way. It could be management alerting the board through the risk committee, or it could be management itself taking action.
Well, assume for a moment that it's a decision of management.
Mm-hmm.
Whose decision is it? Yours?
It would be my decision to instigate that with the board, or to escalate up my management line.
To who?
Both of those avenues.
Who would you escalate it to?
Initially, to up my. At the moment, the Chief Operating Officer, who I report to.
Is that the Chief Operating Officer of the Commonwealth Bank?
No, initially the escalation would be to my immediate boss.
Who is?
Michael Venter, the Chief Operating Officer.
Of what?
Of the Wealth Management Division.
Of the Commonwealth Bank?
I would also have ability to escalate directly with the Executive Committee. I would also have ability to escalate directly with the CBA board if I thought that was warranted.
With the CBA board?
I could do that, yes, I could raise an issue.
Why would you raise with the CBA board whether or not it was appropriate for two separate legal entities with their own contractual arrangements to take action against another Commonwealth Bank entity?
I don't think that's the context in which I meant that. If CIFSL was going to take action against another CBA entity, you're right, that would be with the CIFSL board, yes. Sorry, I was talking about management escalations on the issue.
I see.
Yes.
You're aware of the fees for no service issues that Commonwealth Bank has had?
Yes, I am.
And you know that Commonwealth Bank group entities have charged more fees for no service than any other financial services entity in the country? Do you know that?
I do know that.
It would be the gold medalist if ASIC was handing out medals for fees for no service, wouldn't it?
Yes.
And at any point in time, have you considered whether or not it is appropriate for the entities that you manage to take action of any kind in respect of the deduction of fees from client accounts that you manage?
Sorry, say that again. Take action. In the case of Commonwealth financial planning, we were satisfied that Commonwealth financial planning and CBA were investigating and remediating where this issue had occurred.
When did you become satisfied of that fact?
The open advice review in 2014 is when it was very obvious the extent to which, as I said, both Commonwealth Bank and the licensee were investigating not only the fee for no service issue but issues within the Commonwealth Bank. Actually, in 2014, the issues were related to inappropriate advice. I think out of those investigations and the desire to look further, the fee for no service issue arose.
Just as I put to you earlier that you could require the licensee to certify that a fee disclosure statement's been received, you could do the same in respect of the provision of ongoing advice, couldn't you?
We could do it, yes.
Have you thought about doing it?
We have thought about doing it. Sorry, are you saying again the renewal notice?
No, I'm not. I'm saying separately to the renewal notice, the issue, or one of the issues that Commonwealth Financial Planning and other entities within the group is in a remediation program for is the provision, is the charging of fees without receiving a service.
Yes.
You understand that?
I do.
And in many cases, those fees would have been deducted from, by way of platforms that you operate.
Yes.
And I'm asking you if at any point you have considered whether or not it would be appropriate for you to require the dealer groups to certify in respect of each customer that they have complied with their obligations to provide service.
Well, I'm using the dealer terms of trade to do that, and I do agree we should look at how we could strengthen the way we're administering that dealer terms of trade.
But you're not really using the dealer terms of trade to do that, are you? You're just pointing to the fact that there is at least a possibility that if you wanted to, you could do something.
In relation to the Commonwealth financial planning incident, as I've already said to you, when we became aware of the matter, we were also aware of the open advice review and the seriousness with which they were taking around that the remediation. I can certainly assure you, as the product issuer, I was very unhappy at what was happening. Excuse me, but I did believe that allowing Commonwealth Financial Planning to investigate and carry out their remediation was the best, was going to get the best outcome for our members.
Did you consider whether you had any independent obligation to remediate your members?
Again, because we were satisfied that they were going to be remediated, I didn't consider that. I did, however, consider and have considered in hindsight, now that we can see the full extent of what happened, I have turned my mind to what could I have done differently, or was there interventions that I could have taken. And I would still, even looking back in hindsight, say that allowing Commonwealth Financial Planning to carry out the investigation and remediation was what gave the best result to the end customers. If I, with the limited knowledge and view I had of the issue, was trying to make unilateral decisions or impose my own outcomes, it actually could have either confused the remediation or, in some cases, even caused a detriment for the client.
While it might be the gold medalist, Commonwealth Bank's not the only entity that's had fee for no service problems.
Yes.
Have you written to any other dealer groups seeking any confirmation in respect of the provision of fees for no service?
No, again, we're relying on the dealer terms of trade.
But I asked you earlier, how would it be that you would become aware of a dealer group breaching an obligation pardon me, under the Corporations Act that would engage the dealer terms of trade, and your answer to me was you would expect them to self-report. Is that right?
That is right.
All right. You understand, don't you, that fee disclosure statements were brought in as part of the FOFA regime,
Yes.
and that at least part of the purpose of fee disclosure statements is it minimises the prospect of passive arrangements where fees are being deducted without services being provided.
Yes.
And notwithstanding that is one of the intentions of fee disclosure statements, you still haven't put in place any regime to satisfy yourself that they're being issued.
Not in relation to the fee disclosure statements, but the improvements that we have put in place. We did also, in CIFSL, update the terms of trade to have specific clauses in relation to the opt-in provisions. And in addition, as I've said, to the fee disclosure statement, the renewal process, we've also done a lot of work to improve our own disclosure to the customer in relation to those fees. We carried out a major, what we call a customer-centred design piece of work around the periodic statement to ensure that we were at best practice in terms of how we were disclosing ourselves, the fees that related to those services to customers. And in the case of Commonwealth Financial Planning, where they're using the First Choice platform, over that same period of time, we've also made that periodic disclosure available, because one of the other problems we see sometimes is people don't necessarily engage with their statement as much as we'd like. So we've made those statements available to them in the NetBank portal and the CommBank app to increase the presence of them and the visibility of the fees for the customer.
And those statements would typically, in respect of an ongoing service arrangement, say something like advisor service fee?
Yes.
And has that been changed?
Changed.
In the improvements that you've just been speaking about, has there been any change to the way that ongoing service fees are presented on the statement that the consumer looks at?
It's the entirety of the statement and the way it looks and the way the transactions are made very clear, and that the label on the fee, of course, they're separated out and labelled as advisor service fees.
Was that not the case before this project that you're speaking of now?
The project that I'm speaking of improved the overall readability of the statement. So it has been an issue in our industry that customers do find disclosure hard to understand, and we were aware of that. And as we were moving into the FOFA regime alongside the fee disclosure statement, we wanted to carry out this piece of work so that we could get even more comfort that our statements were able to be read and understood by customers. So a lot of the change is in the layout and design and clarity of the statement.
Is there an explanation in the statements of what an advisor service fee is?
I'd have to check whether, I think there is, but I'd have to check.
You think that there is?
I'd have to check as to what the written explanation is. In the statement, what is very clear is the dollar amount coming out of their account and the impact that has on their account.
Yes, I understand that, but my question was, is there a statement within the document that explains what an advisor service fee is?
I don't have it in front of me. I think there would be, but I don't want to say that definitively if I don't have it in front of me. I said the fee is very clear, and there are notes, as well as the statement, there's notes attached, yes.
Have there been any other major changes to your business as a consequence of the FOFA reforms?
So obviously the implementation of the FOFA, all of the things that we've spoken about are the changes that we've undergone.
And those changes, if I can summarise them quickly, are the banning on shelf
Yes.
space,
And commission.
volume fees, subject to 2 exceptions, the grandfathering of commissions.
Yes.
Anything else?
There's been a range of regulatory reforms over that time. I'm sorry,
I'm just trying to understand how...
Obviously, we implemented all of FOFA.
Yes.
Yeah.
But insofar as how you interact with a consumer, the principal change to your internal business processes as a consequence of FOFA is the redesign of the statement to try and give greater visibility of the fees. Is that your evidence?
See, the redesign of the statement wasn't necessarily a FOFA initiative. It was an initiative probably that we would have undertaken anyway, but it certainly does complement. We're continually looking for improvement and ways to do things better, and the statement would fit into that category. But it was of comfort to us that it ensured that the disclosure in relation to those fees was clearer.
If you were to take some of the steps that we've spoken of in the course of your evidence today, directed to ensuring that clients have a better understanding of their the fees that they are being charged, and requiring your business to have a better understanding of whether or not those fees have been properly disclosed and whether service has been properly provided, would that reflect itself in an additional fee?
Sorry, I didn't understand.
Would you increase the fees that
Are
you
you talking about
charge?
the regulatory reform fee?
Yes.
Yes.
Is that a separate fee?
That is a separate fee that we've been charging in order to recoup some of the regulatory reform costs.
And how's that fee calculated?
We, in the first year, well, every year we carry out a process of looking at the regulatory reform, and this is not just FOFA, this is all of the regulatory reform that has been undertaken over that period, and we then, consider of that what is appropriate to be passed on in regard to ensuring that it's not part of already duplicated in the administration fee, that is genuinely additional cost that. Sorry, if I go back a step, the alternative would have been to have increased the administration fee.
Yes.
Rather than doing that. Our view was to calculate what's appropriate to be passed on with a view that, and charge that annually with a view that that fee will cease at some point.
When did you first start charging that fee?
I think the date is in my witness statement. I'd have to check.
Do you remember the year?
Is it 2012?
Was it before FOFA?
Sorry, I can't remember the date, but
That's all right.
would be in the fee table.
But it's been charged for some years.
Yes, it has.
And is it charged as a flat fee, applied equally to all, or is it charged as on a prorated basis of a total, charged by funds under management?
Yeah, it's included in the. It's charged by redeeming units from the individual account.
But what's the basis upon which the redemption takes place? Is it funds under management?
It differs. It part of the consideration in charging the fee. There's a cap. So the details are in my witness statement.
All right, but just let me ask a simple question. Is it calculated by reference to funds under management?
I believe in some cases, yes.
When you say some cases, do you mean some years, or do you mean it's charged in a different way for different products?
There's a cap as well.
No. My question was...
Yes, the answer is yes.
No, I'm not sure the answer can sensibly be yes. My question was, when you say it's charged differently in different ways, do you mean it's charged in different ways in different years? Or do you mean it's charged in different ways in respect of different products?
Different products.
Different products. So some products, the consumers would pay, what did you describe it as, a regulatory reform charge fee based on funds under management, and others would pay it on a differential basis, perhaps a fixed fee?
I need the detail in front of me.
All right.
The detail is in my witness statement.
All right. And that's been charged for some years now. Is there any plan at the moment for when that charge might stop?
We assess it every year in relation to what has occurred. Our plan is for the fee to stop, and that's why it's separate.
Do you recall now how that fee is described in statements sent to customers?
I'd need to see the statement, but it would be disclosed in the statement, yes.
As a separate line item?
I believe so, yes.
And do you know if on the statement there would be an explanation of what that fee is, or would that explanation come from another
I
document?
think it is on the statement, but without it in front of me, I don't want to be categoric.
Thank you. Commissioner, I have no further questions.
Yes, thank you. Can I just take you back, Ms Elkins, to the dealer terms of trade point? They can include an obligation on each dealer group to comply with its obligations under relevant laws. Can you explain to me how making a contract with someone that they will obey the law has any effect?
It's a warranty, and the obligation is to inform us where that's not the case. That's right.
So the term is not just to obey the law, but is there an express term in the dealer terms to report any breach?
Yes, there is.
I see. Anything arising out of that, Mr Costello?
No, thank you, Commissioner.
No, thank you. Does any party other than Commonwealth Bank seek leave to cross-examine? No? Very well. Anything in?
Nothing further, Commissioner.
No. Thank you. Thank you, Ms Elkins. I step down. You're excused. Where to, Mr Hodge?
The next witness is Ms Perkovich. Could we just take a 5-minute break to again do a reorganisation, and then we'll keep going?
Certainly, if I come back at shortly before 20 to 1.
Thank you, Commissioner.
Yes.